Всем добрый день. Видимо, люди еще будут подключаться у нас сегодня. Сегодня у нас
So
19
good afternoon. Today we have the 19th regular meeting. In the chat, I shared a link for our broadcasting in YouTube. So we have a broadcasting and we'll have the link with records, which you can share. Let me remind you that it is the 19th discussion with the non-refoulement principle as a topic, and we'll have a presenter who will make a presentation. Today we have with us Elina Steinerte. Let me remind you that the organizers from the last May, we had few institutions, including Kazakhstan institutions, Association on the Prevention of Torture, in cooperation with few members of the Committee Against Tortures, International Council for Rehabilitation of Victims of Tortures, World Organization Against Tortures, and some of our partners from the Civil Solidarity Platform Working Group on the Prevention of Tortures. If you remember, the only expert that never cheats on us, it's Elena Steinerte, Professor Steinerte. Thank you so much for joining us today. Let me remind you that Elena was the chair of the UN Working Group on Arbitrary Detention, and she's the member of the UN Subcommittee Against Tortures. And Elena would like to make a few announcements. First of all, that she's going to tell us about the general comment number 1 by the UN Subcommittee Against Tortures, and that the feedback or report is already available of the government of Kazakhstan to the first 3 concluding observations by the UN Committee Against Torture about investigation of January events, about casualties and abuse of power in the army and access of prisoners to medical services. So let me remind you again that the principles of non-refoulement. Okay, Elena, let us check if you can switch on your PowerPoint. Good afternoon, dear ladies and gentlemen. I have to excuse myself, I don't have my access to the Russian version of the presentation. I'm looking for your support in sharing the screen. Okay, then I'd like to give the floor to you, and let me remind you of the format. The format is the following: 7 to 10 minutes will be the main presentation, then questions, and then discussion. No more than 2 hours will be allocated for the meeting. Please prepare your questions, comments. I see a number of experts who joined us, like Evgeny Zhovtis. Most likely he would be able to take the floor. Please prepare your questions. Let me remind you that we have interpretation enabled. If you don't speak English, please press the globe sign at the bottom of your screen and choose the language of a preference, Russian or English. Now I will sharing my screen, and Alina, you can start. I will make my presentation in English, and if you need interpretation into Russian, please use the globe icon which you have in the bottom of your screen. So we have a globe sign, interpretation. If you press it, you would see options, English and Russian languages. Let's wait a minute. Yeah, it's already on the screen. You can see my PowerPoint now. Thank you so much.
Ladies and gentlemen, it is my pleasure to be with you again at this already the 19th discussion around the concluding observations of the Committee Against Torture, which were issued in relation to Kazakhstan, as we all know, last year. So this time we are talking specifically about two two paragraphs of these concluding observations as they relate to one of the most fundamental principles of the Convention Against Torture, and that is the principle of non-refoulement. So if we go, so these are the paragraphs 35 and 36 of the concluding observations. And if we move on to my first substantive slide, please. Thank you very much. So here you have Article 3 as it stands in the Convention on Against Torture, and it reflects what we know in international law, the prohibition of the principle of non-refoulement, the prohibition of refouling. So this prohibition of non-refoulement, which is codified in Article 3 of the Convention Against Torture, really underscores one of the most important fundamental principles of general international law, which is based partly on the case law of human rights treaty monitoring bodies. And this principle is that a state would be in breach, would violate its absolute prohibition of torture, not only if its authorities are actually subjecting a person to torture, but also if its authorities send a person to another state where there are substantial grounds for believing that the person would be in danger of being subjected to torture. And you can see quite a for lawyers in the audience, you can notice a very important use of language. It is talking about substantial grounds believing, so not absolute 100% guarantee. You can also see that Article 3 is only talking about torture as opposed to torture and other cruel, inhuman, or degrading treatment. And that the person would be in danger of, rather than definitely, absolutely, 100% would be subjected to torture. Now, these are very important legal terms, legal qualifications, which we will return to, but I wanted to draw your attention straight away. If we look at the jurisprudence of the Committee Against Torture, the vast majority of individual complaints decided by the CAT Committee actually concern Article 3, and it will come perhaps as no surprise to the lawyers in the audience today that most violations found by the committee actually were not directed against states who are practicing or being found there that their authorities are practicing torture themselves, but actually against asylum states where the authorities have rejected asylum requests and then decided to return the asylum seeker to their country of origin. The wording of Article 3, as I already mentioned to you straight up front, raises a number of very important interpretation questions, and one notable exclusion that we already highlighted was that it talks about torture only. Other forms of ill treatment, cruel, inhuman, degrading treatment of punishment does not fall under the scope of Article 3 of the Convention Against Torture. And this is very different if we compare it to, for example, the regional treaties. And this is a very important threshold element that needs to be taken into account. Now, although the text of Article 3 of the Convention Against Torture only speaks of expulsion, refoulement, and extradition, this provision covers all forms of obligatory departure of a human being, be this alien or citizen, from one jurisdiction to another, including forms of ordinary or extraordinary rendition, practices which I'm sure you have heard of a lot, especially in the context of so-called Guantanamo Bay cases. What is important here to remember is that requesting diplomatic assurances from the government with a known record of torture is nothing but an attempt to circumvent the absolute prohibition of non-refoulement, and therefore does not relieve the respective government from their obligations under Article 3 of Convention Against Torture, because these obligations are absolute and they are non-derogable. which can pose a conflict, for example, with 1951 Refugee Convention, which allows refusing asylum if a person has committed a serious crime and even return that person to the country of origin. But prohibition in Article 3 of the Torture Convention is absolute, which is not subject to any exclusion or limitation clause whatsoever. So if I may ask to move on to the next slide, please. There's only 2 more slides left, so not much. What the state authorities need to take into account when they are assessing the risk of torture in the home country? The domestic authorities in the host state, so the country where the person is, the committee, as well as this host country, must apply both objective and subjective tests in order to ascertain whether risk of torture actually is prevalent in the particular case. And if you remember the wording of Article 3, which I was highlighting at the beginning, it is not that the person will be tortured, but is in danger of. And this is very important qualifying language, which we must bear in mind as we look and examine the obligations of this risk assessment that the national authorities must undertake. So the applicant, the person who is lodging the application, bears the burden of establishing only a prima facie case by providing substantial grounds going beyond mere theory or a suspicion that the torture is objectively being practiced in the country of return, and that the applicant runs a personal risk of being subjected to torture upon return. If there actually does exist a consistent pattern of gross, flagrant, or mass violations of human rights, above all systematic practice of torture in the home country, it is up to the government of the host state to provide evidence why the applicant would not be at the risk of torture. But if such systematic practice does not exist, there is a strong burden on the applicant to provide some evidence. For example, that the person has been tortured before, that there is some medical evidence, etc. And this is the evidence that needs to be provided about personal risk and present risk. Not a risk that existed in the past, but something that would happen to the person if that person would be returned today when this examination is taking place. But as I already mentioned to you, the risk does not have to meet the test of being highly probable, because the overarching aim of the non-refoulement principle is to ensure that the security of the applicant is not endangered. In other words, since the state authorities usually have better access to relevant information than individual asylum seekers, the burden of proof is on the domestic authorities of the host country to investigate both the general human rights situation in the home country as well as the personal situation of the applicant if that applicant would be returned. Now, since the domestic authorities take their decision on the basis of all information available at the time of deciding on the expulsion, extradition, or actual deportation of the applicant, the committee against torture, the treaty body under the Convention Against Torture, when deciding on a possible violation of Article 3 by the host state, must also base its risk assessment on the facts which the domestic authorities knew or should have known at that specific point in time. Now, it is also important that asylum procedures distinguish between asylum applications based on Article 3 of the Convention Against Torture and other applications. In this regard, the committee recommends that the situations covered by Article 3 should be subject of a more rigorous risk assessment, including by systematically holding individual interviews, to better assess the personal risks to the applicant and by providing interpretation services free of charge, taking other measures such as, for example, being gender sensitive during the interview so that the female officers are interviewing the female applicants, etc. And now to the final slide of my very brief introductory remarks today. Article 3 entails, thank you, Anara. Article 3 entails an obligation to advise the persons who are being expelled, returned, or extradited that they have the right not to be sent back to a country where they are substantial grounds for believing that they would be in danger of being subjected to torture. Now, these are what I have listed here for you in the slide are the core obligations that the states must bear in mind as they implement Article 3 of the Convention Against Torture. Now, this obligation to advise is a positive obligation, which requires actually that the states honestly tell the person, if you have any fear of being tortured in your country, tell us, because it is your right not to be sent back if you are in risk of torture. Of course, as you can imagine, it's one of those obligations which many states struggle with implementing. Now, persons who have been returned, who have been refused admission, so they are being returned back, they should be automatically entitled to lodge asylum request and should be informed of this right in a language which they understand. So if the person is indeed at the risk of falling under Article 3 of the Convention Against Torture, this person should be automatically entitled to lodge asylum request. Now here, and this is one of the elements where we come really to the crux of what we see the Committee Against Torture asking of the government of Kazakhstan in its concluding observations. Now, the committee has considered that it is unfair that persons arriving at a border with false travel documents or who fail to declare themselves immediately to be asylum seekers could be sent back to their country of origin. It was also a matter of concern for the committee that aliens entering a country without travel documents were not provided with the services of free interpreter. What the essence is here is that the opportunity should exist at the border for the individuals to come forward and to declare their intentions. All this also means that the states have a positive obligation to ensure that public officials have been made aware of their obligations and receive a broad and special training on Article 3 related obligations. Especially this comes down to the border police, which should be trained in order to recognize torture victims and to ensure that the bona fide good faith victims are not being sent back. Equally, immigration officials who are carrying out refugee status reviews should receive specific Article 3 Convention Against Torture training to understand properly the obligations of the state under this provision, specifically that of the prohibition of non-refoulement. And finally, Article 3 also implies the establishment of a competent administrative body in this field. States should regulate procedures for dealing with and deciding on application for asylum and refugee status, which envisages the opportunity for applicants to attend formal hearings and to make any submissions as may be relevant to the right which they are invoking, including presenting evidence. The crucial element here is that individual assessment of each case must take place. Now, finally, and this is not formally part of Article 3. Sorry, Anara, could we just go back to that slide? Анара, можно попросить последний слайд, пожалуйста?
Сейчас, секундочку.
Спасибо, Анара. Я хотела, I just wanted to very briefly also bring to your attention, and I think this is particularly relevant as we talk about the oversight over place of deprivation of liberty, but also oversight in the way countries are implementing their obligations. And in my final slide, the very bottom, you see I have mentioned the post-deportation monitoring, and there is actually a link to one of the civil society organizations which are specifically working in this area. And the idea is that once you send the person away from the host country, return the person, the question is what is happening with this country, with this individual, and whether this individual indeed is not being subjected to any adverse treatment. So post-deportation monitoring is something that we see more and more civil society organizations and international lawyers talking about. And I think it was very pertinent also to mention this in the context of this presentation. Now, Anara already mentioned that we have very good news this week from the Subcommittee on Prevention of Torture, on which I have the honor of serving, in that some of you know that for the past few years, SPT has been working on its first general comment on which concerns obligations under Article 4 of the optional protocol, more specifically on the term place of deprivation of liberty. Now, I'm delighted to let you know that the final text, as adopted by the SPT, is public and available at the moment only in English, as other languages are still in the pipeline. But I wanted to draw this to your attention. And in the context of our topic of discussion, so the asylum seeking procedures and the principle of non-refoulement, I also wanted to highlight that this general comment makes it absolutely clear that any immigration holding facilities, asylum holding facilities, be these at international borders, at the crossing points, be they in transit zones, or be they purely administrative detention places where individuals are held in the course of immigration proceedings, all of these very clearly fall under Article 4 of the optional protocol and therefore fall under the mandate of the national preventive mechanisms and that of the SPT. Now, on that note, I shall stop here and happily take any questions that you might have. Спасибо.
Dear attendees, now the floor is open for questions. Please go on. You can unmute yourself, switch on your cameras. If no questions, then let me remind you that in the chat, we shared the text of concluding observations 35-36 to Kazakhstan. And today we talk about the principle of asylum seeking and non-refoulement. Of course, different efforts are taken by the country, but still there are concerns that the provisions of the criminal code, the code of administrative violations, which governs deportation or extradition, do not contain the non-refoulement system, and as a result, the asylum seekers are not released from criminal liability in case of illegal entry using fake documents or illegal stay in Kazakhstan, even if the consideration of this case is still pending. And another point, the national laws envisage the opportunity to file the asylum seeking at the border, but the committee is concerned about information sharing between the border service of Kazakhstan, transit areas, airports, and local executive bodies. And the Committee Against Torture marks that Kazakhstan has not joined the Convention of 1951 about apartheid and Convention of 1961 about reducing this statelessness. In the next paragraph, the Committee Against Torture recommends the member state that no one could be extradited, returned, or given out to another state if there are serious grounds to believe that this individual would be subjected to risk of torture. It is necessary to take steps, legislative steps, to amend the applicable laws and regulations that govern deportation or expulsion for illegal crossing of the border or violation of migratory legislation in accordance with the non-refoulement principle. And in this regard, the member state should not expel the individuals seeking for asylum or refugees from their territory before the final decision is made, including that of on appeal. The member state is encouraged to introduce the procedure for asylum, and the committee is urging the member state to join the Convention on the Apartheid Status 1954 and Convention on reducing the statelessness of 1961. So the Committee Against Tortures has already issued its comment that Kazakhstan is violating the principles which Madam Steinerte was referring to. Well, we cannot say that all these decisions have been put in practice because there is no legislative procedure, and the Code of Procedures do not contain provisions to review the judgments based on the recommendations of the Committee of Tortures. Let me also state that in the end of May, amendments were introduced into the migration law, but those were largely made stricter. What we can say about the applicable laws, Code of Criminal Procedure, went further the minimum guarantees, not only because of a threat of torture, but also because of risk of death penalty. So the extradition has been prohibited to countries where there is such a risk. Okay, let's start a round of discussions. If you have any questions, we'll be happy to talk to you. Please unmute yourself. I don't see any hands raised for now. Sabirjan Sijanov, please. Mr. Sabirjan, over to you. Good afternoon, dear Anar, dear Elena Steinerte. I have a question. In the last slide, I saw automated right for providing an asylum. Can you elaborate? Because I know that the sheltering is not automatically presented in the laws. Maybe it's not a clear translation. That's why I usually use the interpreter. Automatic right to file a request for sheltering. Right, that's what I meant. My apologies for that. Okay. In the beginning, you made a reservation that if there is a risk of torture against an individual, but there was, except for other types of cruel treatment, in my understanding, even if there is a risk of cruel treatment, degrading, it's not a ground to extradite or return the person, right? Or not under Article 3. Article 3 of the Convention Against Torture, in this respect, is rather limited, i.e. Article 3 talks about tortures only. So you cannot return individual to a country where he or she could be subjected to a risk of torture. But if it is a risk, like in a risk of ill treatment, it doesn't fall under the Article 3 of the Convention Against Torture. Well, there are some other legal tools and mechanisms that could impact the situation, but the Article 3 of the Convention Against Torture clearly states exclusively about tortures, risk of tortures. Okay, then what about cruel treatment or degrading treatment? Which articles of the article would cover this? Well, then it is Article 16 together with Article 3. For instance, you can formulate it this way, and there is a definition of torture in Article 1. We know that jurisprudence of the Committee Against Torture about this issue, at which moment the cruel treatment turns into torture, right? And then you can say that this cruel treatment has already reached the level of torture. Thank you so much. Thank you so much. Hello, Lina, Anara. I have a question. The question is about possible torture. For instance, if a person is brought back to home or a country of departure, should we prove that they could be facts of torture, or it would be enough to state or declare, or some existing decisions by UN committee could be presented? Like there was a case, Anara helped me a lot, this case for two citizens, two ladies citizens of Belarus. They were arrested in Kazakhstan and they wanted to extradite them to Belarus on political grounds. And they stated that most likely they will be subjected to ill treatment and tortures when they are brought back to Belarus. Thank you for the answer. Well, Article 3, what we see in the jurisprudence of the Committee Against Torture, there are like two ways to go. Is it a systematic practice of tortures? And then we can say that countries like Democratic Republic of Congo, Turkey, Iran, Peru, for instance. So there is a jurisprudence of Committee Against Tortures, which clearly state that these countries have signs or they have systematic practice of tortures. And in this case, this element of proof, if I can say so, it's easier to pass. If we say about countries where they don't have well-established jurisprudence by the Committee of Tortures, then it would be rather challenging to detect this element. But in all other cases, it is important that these two elements, personal risk and current risks, not what may happen like before in the past, but that this particular individual at the particular time has a risk of being subject to torture. So this is element of proof. Thank you so much. Anara, may I add, please, Gulmira Kotbekova, the lawyer of the Kazakhstan Bureau for Human Rights. I'm a lawyer of the International Bureau for Human Rights in Kazakhstan, and I provide support to the individuals under the UNHCR. And I have a question about the applicable practices. What about illegal crossing the border? I mean, in our law on refugees of 2009, Article 10, paragraph 4, clearly reads that if an individual was arrested for illegal stay in the territory of Kazakhstan and expresses a will to submit an application for the status of refugee, the competent authorities shall notify the local executive bodies. The competent authorities are the staff of the border service, the National Security Committee, which means that in one day they have to submit this application to the respective authority, Ministry of Labor and Social Protection, and we have provincial level departments of social coordination and employment. I mean, there are territorial subdivisions. Okay, let's take East Kazakhstan. On the 12th, the resident of Russian Federation illegally crossed the border. So it was on Friday, so on the 12th of July. And I provided consultation. This individual gave in to the frontier officers. We provided explanation about the international commitments, and the frontier service, the frontier police officers, they know their mandates and provisions of international laws. And this individual immediately stated that he was seeking for asylum in the territory of Kazakhstan. But as a matter of fact, there was a court case for illegal crossing the border, and the measure taken against him was an arrest for 2 months. After this happened, we immediately hired the defense lawyer. We have a lawyer in the East Kazakhstan Bureau for Human Rights. I would like to thank them. Well, of course, they were involved, and we're referring to Article 31 of the Convention on the Refugees. The country will not punish for illegal crossing the border, but the court did not take this into account and imposed a sanction of 2 months of deprivation of liberty. We seem to be complying with obligations. I will not give out the names because we have some confidential information about the asylum seekers, and if they agree, would not share their names. Well, because of this conflict between Russian Federation and Ukraine, there were so many asylum seekers, and they have certain proofs, some evidence, and the law reads, if it is a political reason, then the government has to carefully review all this presented evidence and provide the status of the asylum. But they do not take into account all these mandates, and they sometimes ignore the evidence and expel the individuals to their home country. Well, Kazakhstan, in terms of the practices, does some good. They do not extradite. They can release under the extradition list, and the individuals can travel to a third country, but it will not happen all the time that they allow an individual to cross the border to a third country. What to do about those individuals who do not fall under this criteria? They cannot stay legally in the country, and then it also means that they can be expelled, they can be extradited to the country of origin, right? Thank you so much. Thank you so much, Gulmira, for this example and for expressing your concerns because of violations of treaties. Birjan, you would like to take the floor again? No, I would like to comment the Gulmira's intervention. So we have a discussion, right? Yes, please, of course. Or do we have this in the end? No, it's just the right time for discussion. Please take the floor. Well, about your case, Gulmira, in general, I agree with you, but let me clarify. You know, I used to work in this system for quite some time, and our authorities, they interpret the obligations of a government not to make liable in the perspective of release from illegal crossing the border, but 2 months deprivation of liberty, this kind of sanction, we cannot agree with if the individual has political grounds for asylum. But it's not his responsibility for violating the border crossing procedure. I just wanted to explain you this. In my thinking, our state authorities interpret the way that release from criminal responsibility only if he gets the refugee status. Only then this individual can be released. But if the individual did not get the refugee status, then all these reprisals will be pressed on him. So he would be made fully liable for this. That's it. Thank you. Elena, would you like to comment on this? I fully agree. There is no venue for comment. The colleagues were absolutely right. In terms of the articles of Convention Against Torture. Thank you so much. I can see Evgeny Zhovtis online. Would you like to take the floor, Evgeny? Yes, with your permission, just a few comments. So, the point is, the first serious issue starts with the application of international treaties in the national law or in the national law enforcement practices. We can refer to the Convention on the Refugee Against Torture, Covenant on Political Civil Rights. But if these treaties are not used by the judiciary or other executive bodies, even though they should be applied because they have a direct effect and they are recorded in the Constitution, like dominating or prevailing over the national laws, they should be applied, but they are not implemented at all. Even in the judiciary practices, the resolution by the Supreme Court, still under the International Treaty of 2008, is not applicable, it's not operational. So it is a situation when the link or reference to the ratified International Treaty on the Human Rights, it's like a reference to some declarations or recommendations. So, as I said, these are ratified treaties on human rights, which should be applied straightforward, and the national laws should be aligned with these requirements, or this international law should be prevailing over the national regulations. So we have to do something about this. Otherwise, it will be like reference political nature rather than legal. I was laying my hopes for the Constitutional Court that as part of the constitutional proceedings, the Constitutional Court would comment on Article 4 of Kazakhstan Constitution in terms of international treaties and the law on international treaties in the way that these treaties would be used in enforcement practices, and they can be referred to as the legal proof or evidence. It's like a document prevailing over the national laws. This is first issue. Issue number two, as you said about this individual from Gulmira's intervention, there is no presumption of an asylum seeker. The government authorities should proceed from understanding that this is an asylum seeker unless you have proven otherwise, unless you have done all the legal procedures related to this, including subjective and objective matters of the case. It's good that we do not refer to the criminal liability for illegal crossing the border, but it should ground on the basis that this individual, asylum seeker, is presumably asylum seeker, and then the state system would work to oppose or to agree And the third point I would like to stress your attention to is that when we have a situation where asylum seekers, especially individuals from neighboring countries like China, Russia, Uzbekistan, and so on, when these citizens substantively may not rely on the asylum seeker status, refugee status, it's not legal reasons, but largely political reasons they cannot apply for refugee status. And when there are grounds for refugee status from the data that he presented, but politically, let's say this individual from Russian Federation may not rely on the asylum, so it's not like turning back, but it's like a soft pressing out. It's a way to address this issue by replacing to another country and so on. And this background creates legal problems because in the very end, it becomes clear that the individual will not get this refugee status, and it just hang in between. So he has grounds to get this refugee status, but no status will be granted, and then this situation should be somehow addressed. So this legal situation, to a certain extent, diminishes guarantees, including the principle of non-refoulement. Thank you so much, Mr. Evgeny. I'd like to ask Elena, would you agree to this intervention? Or
Абсолютно согласна.
yes, I fully agree. I don't see hands raised, but let me note, or let me remind you that there are a few decisions by the European Court of Human Rights, not against Kazakhstan, but related to Kazakhstan and related to the extradition to Kazakhstan. And this is a story with which started in the end of 2000s. First was issued in 2010, Amir Kabulov versus Ukraine, where European Human Rights Court prohibited Ukraine and other countries, members of the Council of Europe, to extradite to Kazakhstan because of tortures and unfair trial. And this repeated in the following cases like Baisakov brothers and others. This decision was somewhat halfway through, and what Elena was talking in her presentation about threat in the present time, the present situation, and personal risk of torture that the applicant has to prove. So this standard repeated in this case, and there are some other cases versus Russia. Why I am telling you this, not just to, where we are and why the prosecutor's office may not get this suspects or defendants back, but also because in terms of countries of Council of Europe, the standard is rather tough. For the last 40 years, we can observe how it is applied. Our states may not get the suspects from the member states of the Council of Europe. This is how it is applied in Europe, and we see sometimes it works, sometimes it doesn't work, but this is the situation for now. Okay, any other volunteers to be part of the discussion? We'll be happy to give you the floor. I know Murat Adam presented some of the applicants, defended some of the applicants. Anara, hello. Yes, right. I presented interests of individuals of Russia. As Evgeny said, I fully agree with him, actually, because this is the case. I mean, all the rights which are guaranteed to such citizens for political asylum, they're just of declarative nature. Nobody cares. Our courts referred to the courts of appeal as a last resort, and there is no other way out. There was a similar situation with the resident of Russian, citizen of Russian Federation. She's journalist. I presented her on the administrative case where we appealed against the department. I don't remember. It's an authorized body responsible for political asylum. I was really shocked with the uh, rejection. So they brought up 5 grounds under the applicable law, but which one was used to reject the application of Evgenia Bolgatarova, we didn't know. And the person left Kazakhstan and now in Europe, even though that individual sincerely believed that she will get some protection in the court, and our administrative court, which works under the Committee Against Tortures, would take correct steps, but we found an absolutely opposite story. The political asylum could be granted only if the applicant belongs to a particular party, and there was no way to prove that she is not a member of a political party. That's why she cannot get political asylum. And Evgenia refused to present the evidence that she's a member of a political party, and that's why she was looking for the political asylum, and she left for Europe. Yes, it is important to understand the scope such violations that you described, and which are um, presented in the concluding observations. One story if it is just one case, and another story if it goes regularly. What's my personal intervention? When we keep monitoring on the protection of the civil rights defenders, safety and security of civil rights activists, we have to put the foreign civil rights activists into the separate group since August last year, because the volume and the number of those who traveled to Kazakhstan and were subjected to such limitation of their rights and failure to comply with minimum international standards to an extent start growing, and at least 15 to 20 individuals were registered. And I confirm what Gulmira and Murad Adams said, that people were in custody and then they could travel to a third country. But another story with the refugees, asylum seekers from Uzbekistan. Probably you, the participants, will have specific examples or cases so that to engage you into the communication. I would thank you for your active participation, please. I don't see any volunteers. Anara, I believe that you talked about extradited individuals, 27, 28 people, right? 2010, 2011. No, not only them. It's Taijon Abdusamatov, 27. There were 38 actually, if I'm not wrong. It was Turksip district of Almaty, so there were many more. But the communications were shared with the committee against torture for 10 people only, just a few less. So they won against the government of Kazakhstan, but there is no enough public information available about each individual as to how this judgment was implemented. This could be available with the members that attended the meeting between Kazakhstan and Committee Against Tortures on their report, and the consular or diplomatic service of Kazakhstan in Uzbekistan. They just monitored and followed on the compliance with requirement not to use tortures. So the embassy of Kazakhstan was monitoring how their rights are exercised in Uzbekistan, but they did not bring them to Kazakhstan because there was a requirement on their return. Not necessarily this case, but there are some other cases of individuals of Uzbekistan who lived in Karakol, Pakistan. Okay, let me take the floor then, just to explain what happened since the events in Uzbekistan about national minorities. Well, we received extradition requests, and they had custody 40 days, then 12 months, and Kazakhstan has some positive practice, like they were not extradited to the country of origin, but based on the order of the prosecutor, these individuals were released. And today we have an issue to transfer them to a third party, to a third country. But to a larger extent, Kazakhstan, the High Commissioner for Refugees' Rights, do not have this resettlement program. Usually it's local executive bodies, and you cannot always rely that these individuals will be replaced or resettled. In the court cases, when the competent authorities report, they say these individuals could be resettled by forgetting criteria like political beliefs or some other criteria which are stated in the Convention on the Refugees. Let me remind you that the convention has F1 that committed the criminal act. And they are they are an exception. They cannot be granted with a political refugee status. But we have to refer to the Convention Against Torture, right? And I agree. And since I'm doing this since 2009 as part of the Code of Criminal Proceedings, but there are some amendments into the Code of Criminal Procedure. The decision is made to review, and the court may not oblige the executive body to grant this refugee status. So every case should be carefully examined. Motions and applications should be carefully analyzed, take into account information about the country of origin. Then they take a decision to revisit, and then they send it back to the executive bodies. Then they revisit, they reject. So you see what's the negative implications. So we rely on the court, but the court has no such powers. They say it's not beyond our competences. We have to oblige the local executive bodies, but every time at every hearing, we raise an issue that the Commission, in accordance with the standard procedures, may not reject the individual consideration, but it just gives recommendations, and the local officers have to finally decide about granting the refugee status. I'd like to say that there are so many situations. If those who receive the refugee status and those who apply are largely individuals from Afghanistan, those who received the status and granted with the status, or whose application were rejected, and they have to present the proof. And the question is how this Afghani resident can present the proof. The procedure for registration of application clearly state that they have to present the evidence from a prosecutor's office or some other agencies. We cannot even prove that these asylum seekers may cross the border without any like travel documents. The refugee case, you cannot compare neither to criminal proceedings or civil proceedings. It's absolutely different story, and I'm offering the mediation agreement as a solution with the local executive bodies, especially in Almaty. They have the determinations. I don't know. granting the refugee status is not a political nature, right? It's a act of humanity. It's a humane act. But it happened that we cannot prove. There were some journalists from Afghanistan with all the proof and evidence in hand, but these were ignored. And of course, we refer to different resorts, and the Supreme Court rejects in the revision of the case. And again, we have to return these individuals to the country of origin. So this is long story short. So thank you so much. I have a question, please. I'd like to clarify, as part of this about the case, what is the determination of a court because of some administrative, or the court may not oblige the respective authorities to grant the status? No. In other provinces, like in the Karaganda, Jambul province, they issued some determinations on revision of a case. The court authorized or obliged the local executive body to review the case, and the authorized body immediately rejects. So we go back to the legal perspective. In Almaty, do you have any decision where the court would oblige the competent authority to review their decision? They can see that the defendant presented proof there are gross violations by the competent authority, like the Department of Employment and Social Protection in Almaty province or some other provincial level authority, like in Almaty. They can see all the violations and proof, and they ask the competent authority, will you revisit your decision? They say yes. Okay, let's issue an determination. Let's make a revocation. It's like they revoke the claim, they revisit, as I said, under the code of administrative violation, they can enter into the mediation agreement, but the approaches vary, and there is no decision in Almaty. Okay, would you give a specific recommendation because of this? Well, as a lawyer that has an extensive experience in refugee cases, they say that we should switch off our emotions, but I cannot switch them off because we talk about people, right? Human beings, and we are not insured against anything that happens with us. It's an act of humane, and we have to carefully learn the motion of an individual. We have to learn what's going on in the country of origin of that individual. In this case, I would like to recommend that under the Code of Administrative Procedure, it's not like a mere decision, but the court should be authorized to oblige the competent authority to grant the refugee status. Otherwise, it should be like a enabling act that the court obliges the competent authority to grant this refugee status. Yeah, may I add, please? I'd like to say, principle, the Code of Administrative Procedures envisages for such an opportunity. For instance, we had a case with the citizen of Russian Federation, which now lives in Europe, in France, and there is a prerequisite for the competent authority to issue a positive determination, but the court rejects to mandate the competent authority to issue favorable decision. So they are not brave, right? And they may not take such a decision. Thank you so much. That's what we're talking about. Okay, Sabarjan, over to you.
Сабуржан, вы руку подняли или
Да.
Yes, correct.
Просто небольшая рекомендация. В принципе,
Allah,
очень
I have a
интересно
short
было
recommendation. Gulmira was absolutely right in saying her
наделение
recommendations about
судов
empowering
возможностью
courts
принимать решения. Не знаю,
to
могут ссылки
take decisions. Well, I'm not a specialist on
соответствует,
procedures,
не соответствует этому
whether it is
Но я бы предложил
aligned
свою рекомендацию
with the
немножечко
code, but I have a
возвращаясь к
recommendation
началу.
coming back to
Хотелось
the
бы обратить
beginning.
внимание, что вообще
Let
вопрос
me
экстрадиции у нас
say that
решается
extradition
Генеральной
is
прокуратурой.
a duty of the
Давайте
General
возвращаться
Prosecutor's Office.
к началу
Okay,
вещей.
let's clarify that.
То
Let's
есть
get
лица,
back to the
которые
beginning. So
обычно же у нас
individuals
что лица, которые преследуются на родине, у
which
них
are
возбуждаются уголовные дела в
prosecuted
отношении них по тем или
or
иным
reprised,
основаниям.
they have cases against
И
them
они,
in their
пытаясь избежать этого
home
процесса,
countries, and trying to avoid
переезжают в
this,
другую страну.
they start traveling from
Естественно,
one
они
country to another,
возвращаются
from
в
one
эту
country to
страну.
another. And coming
И
here,
далее
they
приходит
try to seek some
розыск
support,
в
and
отношении этих граждан. То есть они
they
задерживаются,
are in the wanted
приезжают,
list,
и их
and they are
рекомендация, решение
arrested,
по поводу
and
получения
their
статуса беженца — это одна из форм, как бы избежать
requests
экстрадиции
of
на родину.
asylum is just a
Поэтому
way
я бы
to avoid
рекомендовал изучить
extradition
этот
back
вопрос,
to home.
насколько
So I would
это,
like
и
to
обсудить со
propose to
специалистами,
carefully learn the
со
situation with
специалистами
that,
о том,
how
что
well
вопросы
this is
экстрадиции
aligned.
принимает решение прокуратура. Я понимаю, что она, в принципе,
I
экстрадиция рассматривается, в принципе, прокуратурой
extradition
всех
is
стран СНГ. Ну,
a job for the
безусловно,
General Prosecutor's
для
Office, and this is
более
for countries of former
законно
Soviet
или
Union. But I think it would be
более
more
правильно,
legal
как бы
or
вот
more, I don't
синоним,
know
если мы
what
передадим вопрос
word to use.
экстрадиции в ведение
So
суда.
if
И таким
extradition
образом
would be
все
a
более
mandate for the court,
обоснованно будут
then there
рассматриваться
will be more
вопросы
justified
оправдания
or more objective
возврата или невозврата,
determinations
возможности
to
убыток
return
и
the
в
individual
этом
back to
случае
home
может
country or
быть и
country of origin, or a risk of torture.
обжаловать
Then
решение, то есть об
this could be
экстрадиции.
appealed against. This decision on
Извините,
extradition could
пожалуйста,
be appealed
бурно,
against.
просто сейчас
Sorry for
адский
my
вопрос.
chaotic thoughts,
Да,
but this is
конечно.
just
Вот
came
здесь
to my
Лина,
mind.
эксперт, пожалуйста,
We have
вопрос.
Elena. Please, over to you.
Элина Штейнерте.
Аннара, у меня нету комментариев по этому
I don't
вопросу.
have comments on that, Elena.
Я увидела вашу
Okay.
руку, думаю, надо вас
Руку
I
мою.
just saw that you raised
Это-
hand. My apologies.
Видно. Хорошо.
Извините, пожалуйста.
My
Комментарии
apologies
мы
for that.
записали, также
Okay,
они в
we
записи останутся
put down the
в
notes.
видеоформате.
We will have
Еще
records
один вопрос был,
and video.
который, может быть,
There was another question,
на мой взгляд, не до
which in
конца
my opinion
обсужден.
has not
Это как же
been
все-таки
discussed in full.
доказать,
How
что
practitioners can
в той
prove
или иной
that
стране человеку грозят пытки.
in one or another country, the individual can be subjected to torture. Some practical issues. Let's discuss together.
Нужно брать несколько документов, как это следует из практики, например, международных
I
договорных
think that we have to rely on few international documents, especially on the treaty bodies' determinations. Okay, coming back to the Committee Against Tortures. One of the observations made, it's a report by Amnesty International about freedom from torture globally and on a country level. Another document that re- led the grounds to the report of the European Human Rights Court, then the US Department of State, and the concluding observations by the Committee Against Torture to a particular state which is seeking for return, refoulement. And this is like a closed loop. And usually we take as basis reports or recommendations by the respective authorities. That's why it is important to monitor what recommendations are provided to the member states and what general comments are made. If you remember, we talked about in the very beginning, and particularly Article 4, general comments number 1, of the Committee on the Prevention of Tortures. Probably, dear colleagues, you will have some considerations how we can prove the fact that this individual in the home country can be subjected to tortures, like some practical toolkit that we should rely on. Now I see your hand raised. Please, Lilina. Now I have my hands raised. I'd like to say that I agree what you said, but let me underscore. If we talk about Article 3 of the Convention Against Torture, then here the jurisprudence of the Committee Against Torture is very important. And as I said in my presentation, individual complaints to the Committee Against Torture, as a matter of fact, in terms of all the cases, all those were cases on the principle of non-refoulement. And there is a large jurisprudence by the Committee Against Torture. As I said, few countries where the Committee of Torture mentioned that they have systematic practice of tortures, then it is a matter of proof. It's a burden of proof. In this case, it will be easier. But not only reports, I don't know how to say it in Russian.
Urgent appeals — это то, что выдают спецпроцедуры, то есть
It's
спецдокладчики.
like under the special procedures of special rapporteurs. You might know that these documents, they are confidential. And then after some time, they become public. And sometimes they give out some names or details of a case. It's about evidence. This is my perspective from international arena. Thank you so much. This is yet another recommendation to the practitioners that have such cases, what to focus on, what documents request. So, Gulmira, it is most likely about the evidence that could be presented with regard to situation in a given country if you support an individual to meet the guarantees which are granted by the Convention on Refugee and Convention Against Torture. Okay, thank you so much. Any more comments which you might have on the go or related to the concluding remark that Kazakhstan received? You remember we talked about the big list of questions which Committee Against Torture marked on fake documents. Related to the criminal violation and as part of some civil proceedings. Please, the floor is open. I don't see any hands raised. Let me comment then. My practice on the fake documents. So, individuals of residents of the Turkish Republic, if you remember, many residents of Turkey were repressed, mostly teachers and business people. Many of them, which could not travel outside, the consular service did not restore, did not issue ID documents for them. Okay, let's take Kazakhstan. Many of them produced fake IDs and they traveled to another country. In my practice, there were individuals of Turkey who stayed in the Kyrgyz Republic and they traveled via Kazakhstan to get to European countries. And upon departure, their IDs were annulled. And this is a positive side of Kazakhstan, that they were not made liable in Kazakhstan, and their motions were transferred to the authorized bodies, and the authorized bodies took the responsibility to release them. Yes, in terms of fake IDs, the practice is still there, but on Kazakhstan side, none of them were made responsible, if this is what you're talking about. So all of them received a chance to talk to the authorized bodies. So it's about border crossing point. If they are arrested and they are in the transit procedure, at each border crossing point, we have billboards that UNHCR and Kazakhstan Bureau for Human Rights provides legal aid. If you have any concerns, please communicate with us. So they receive our contact details. We talk to the airport officers. We try to figure out the details of a case, and there were quite a few. And after filing the motion, they had a chance to win the case. I would like to thank Madam Sterneta for a very important comment, for your participation, because she's excusing herself from a meeting. Thank you so much for your monthly input on a voluntary basis. Let us summarize the meeting for today, because I don't see any more hands raised or unmuted microphones. Today we talked about paragraphs 35 and 36, which of including observations by the Committee Against Torture related to two issues: system of providing the asylum. So if there is a system, then you have everything that can protect, and non-refoulement. So these two paragraphs are very extensive. They touch upon many things. All of them were carefully considered. Some things still need to be reviewed, but there is a recommendation to strictly comply with two conventions: Convention on the Refugee Status and Convention Against Torture. There are specific recommendations to ratify the Committee of 1954 about apartheid and Convention of 1964 on reducing the statelessness. And it is important to mention that there are certain criteria, and there are cases when the individual cannot present the evidence. Maybe this criteria should be revisited. And Sabirjan Sijanov said that if the status of refugee is presented, only then the criminal liability could be discharged. This would require careful consideration, because staying in custody is a rather serious limitation under the Article 9 of the International Covenant on Civil and Political Rights, especially if it's about non-refoulement and investigation. So there is a case like Asylum Ismail against Kazakhstan. It was considered by the Committee Against Tortures, and Kazakhstan was recognized as a violator of few articles of this Covenant on Political Civil Rights, Article 6, freedom of a right to life, because this gentleman was subjected to a risk of death penalty in China. Then he was in custody. It was a reprimand. In a decision, Article 9 was violated, and Article 7 was violated, because the principle of non-refoulement, I don't know how to pronounce it correctly, it was violated anyway, and this person was given out. So first of all, he was in custody, then it was home confinement. The presumption of innocence always touches on the torture. Very important issues were covered by Mr. Evgeny Zhovtis in terms of application of international treaties and the role of the Constitutional Court. And let me add the role of General Prosecutor's Office and Ombudsman, because each of these authority has a function and the competence to refer to the Constitutional Court. I'd like to thank the lawyers, Murat Adam, for touching upon the grounds to the rendition or extradition that the citizen of Russian Federation did not belong to a political party. And it's still a question, should you belong to a political party in order to seek for political asylum? Well, obviously not. Not necessarily to be a member of a political party to get this political asylum. We also talked about the European Court of Human Rights. Also, we talked some positive things about Kazakhstan and comments from Gulmira Kotbekova, having mediation agreements. And having granted the status of refugee should be an act of humanity rather than political reasons. And in the time of crisis, we have to rely to these simple principles which are enshrined international treaties and agreements. So it's act of humanity. Then we talked about the authorities of judges to decide having the authority to mandate the competent authorities to issue facilitative or friendly decisions to the applicants. And then we talked about jurisprudence, importance of jurisprudence of the Committee Against Torture, and focusing on the opinions of the Special Rapporteur, part of appeals, when they ask to take urgent measures. On the fake documents, this practice in Kazakhstan has been proven successful when Kazakhstan was a country of transit and they were allowed to travel across Kazakhstan, and the support or assistance provided by Kazakhstan, Bureau for Human Rights, and the UNHCR office in Kazakhstan. So all the contact details are available. I would like to thank our expert, Madame Steinerte. Let me remind you that she is a current member of the subcommittee against torture. So please refer to the links which Elena shared in the chat. We'll copy those and we will post them in the YouTube channel under video. You can download, first of all, the new general comments, number 1, was the subcommittee on the prevention of torture on Article 4, related to the term places of country or places of detention. And there is a report of Kazakhstan on the first 3 points of concluding observations by the Committee Against Torture. So we'll made them available to you. I'd like to invite the civil society to prepare their comments to this report. So in the end of July, we will hold discussions. Please join, because we will prepare an alternative version how realistic is the situation that government presents in the report. So you'll be kindly invited to join the discussion. So even though you have your summer join, we talked about this system of asylum and non-refoulement system, and if it is a system, then the government should provide for protection and not give out the individual to a seeking country, especially if there is a risk of threat of torture. So we had interpreter Anna, and let me remind you that the Sigrid Rousing Trust covering some costs. So you can watch records, Dignity 5351 in our it's a channel in our account in the YouTube chat. Thank you. Bye bye.